12 minutes. In this video, what we're discussing is mom paid dad child support, but the catch is the children live with mom. This is going to be interesting, right? Nevertheless, this is Antonio with Team Tiggio. If you haven't had a chance to watch any of my videos, make sure you do so. We drop heat on this channel. Make sure you subscribe to the channel. Please hit the like button. The more likes we get on these videos, the more YouTube shares these videos, and it helps the channel to grow, right? We put a lot of work in these videos. Nevertheless, let's dive into the commentary so you can give your feedback.
He still refuses to provide Ms. Smith with his new address. More importantly, the plaintiff has not seen or had contact with the remaining minor children since he moved to Kalamazoo. He's missed their holidays. He didn't even wish them a Merry Christmas. He has not even reached out to my client to ask about the children's well-being. Just a little before moving to Kalamazoo, he did send the children a text message stating that he had sacrificed financial stability and freedom for them, which we attached as an exhibit. Even though he hasn't seen the children in about 6 months, my client, due to the current child support order, has been paying child support to him, even though he hasn't had the children with him and he hasn't provided any financial support.
Court will note the appearance of Mr. Vanderhorst on behalf of plaintiff, Mr. Umlaugh on behalf of defendant. This matter is before the court on the defendant's motion for modification of custody, parenting time, support, and other relief. Mr. Umlaugh.
Your Honor, the parties have 2 children, ages 16 and 14. Their current orders give them joint legal and joint physical custody and equal parenting time of those children. However,
a verbo is for sharing all kinds of moments. From teeing off.
Circumstances have changed significantly. In August of last year, the plaintiff moved from his house in Battle Creek to a 2-bedroom apartment in Kalamazoo, Michigan. He did not tell Ms. Smith when or where he planned to move, and she, in fact, did not learn that he moved to Kalamazoo until months later. He still refuses to provide Ms. Smith with his new address, despite a request that he do so. He hasn't updated his address with Calhoun County friend of the court. It appears he is working for his apartment complex, but I do not know which apartment complex that is in Kalamazoo, and there are many. More importantly, the plaintiff has not seen or had contact with the remaining minor children since he moved to Kalamazoo. He's missed their holidays. He didn't even wish them a Merry Christmas. He hasn't attended their sporting events. He missed the 16-year-old getting her driver's license. He has not even reached out to my client to ask about the children's well-being. Just a little before moving to Kalamazoo, he did send the children a text message stating that he had sacrificed his financial stability and freedom for them, which we attached as an exhibit. Because he now lives approximately 40 minutes away, and the minor children are in Penfield High School and involved in the community, they have several extracurricular activities in this area, it is simply not feasible to continue a 50-50 parenting time schedule. The children have been deeply hurt by the plaintiff's decision to cut them out of his life, and for that reason do not want to go back and do not want to live with him full time, and certainly do not want to live with him half the time. Even though he hasn't seen the children in about 6 months, my client, due to the current child support order, has been paying child support to him, even though he hasn't had the children with him and he hasn't provided any financial support for the children. For this reason, what we are asking is that the court grant my client legal and physical custody of the children and award the plaintiff parenting time at her discretion. We also ask that the child support order be recalculated according to the formula. If the court is inclined to order an evidentiary hearing on this matter, we would request that my client's child support obligation be suspended as we wait for that evidentiary hearing. We would further ask that my client be permitted to claim the minor children as dependents for tax-related purposes, as they have been living with her full time. And again, if the court is inclined to order an evidentiary hearing, I would request that we be permitted discovery to further explore where Mr. Pemberton is living and where he is working, and to get a sense of his income in advance of that hearing. Thank you.
Okay, thank you. Mr. Vanderhorst.
Yeah, thank you, Your Honor. Does the court have my answer?
Yes, yeah, we received that.
Thank you, Your Honor. When we filed that answer, my assistant noticed that my answer was a 201st entry in this case. I'm new to this case. The court's well aware of the long history in this case. The divorce was in 2013. Here we are 11 years later. The parties have 3 children. Mackenzie's 18, Michaela's 16, and Madeline's 14. So the courts has jurisdiction over the 2 younger daughters. There's a lot of false statements in this, Your Honor. My client has given his address. My client has given his address to the friend of the court. My client has not seen the girls. The girls are teenagers now, and it is not because of his doings. Believe that it's just there's just an environment at the home of the mother that does not promote it, that does not respect the court order. And so the defendant here has been really in violation of the court order for the last 6 months. My client did sell his place he had in Battle Creek area, did move to Kalamazoo. That's the most of his work is in the Kalamazoo area. He has a nice 2-bedroom apartment that has a bedroom for the girls to stay. He did purchase a car for them. I believe Michaela can drive now. She's 16, and he loves his daughters very much and would like to continue the parenting time arrangement. There's an established custodial environment with both parents, Your Honor. The other important factor in this case is there was a court order before regarding counseling. And I believe counseling now would be very, very fruitful. And I did reach out to Margaret Hunter, who's a very skilled counselor. I've used her before in other cases that could deal with the family issues we have here with the teenage daughters and the parents. And I have made that known to opposing counsel that Margaret Hunter, I've spoken to her, would be willing to take this case on and get involved with his family to kind of bring healing back to this family. I know the counselor that was court ordered before has retired, so she is no longer practicing, but I believe this case would be just tailor-made for Margaret Hunter. As far as the tax exemptions, there was a court order to that effect back in May of 2015 that awarded the tax exemptions. And my research was, I'll give you, it's been a few years on tax exemptions. They can be either be property where they're non-modifiable if they're awarded, or they could be awarded in child support. But in this case, clearly they were ordered back in 2015, where the parties basically share the children because they've been sharing the children as far as parenting time. So going forward, Your Honor, I would like the order to be enforced. And the issue of child support, my client's willing to say no child support. He would terminate the support as far as I think she's paying $100 a month, Your Honor, something to that effect. Would waive that for now, but he does make substantially less than the defendant. I believe that I haven't subpoenaed incomes or anything, but I believe the defendant is making close to $100,000, if not more. My client he's self-employed, $50,000 or so. So he makes substantially less anyway than the defendant. But I would ask that the court order be followed, Your Honor, that counseling be ordered in this case, once again, with Margie Hunter, who's a very good counselor, that the defendant, not badmouth the plaintiff at home or do anything to that effect, promote the girls to see their father, and to go forward in this case in a positive way. We only have a few more years left before we're across the finish line, and I think counseling actually would be very helpful to these folks.
Okay, thank you.
Your Honor.
Mr. Vanderhorst, when you say that your client's willing to terminate child support, do you mean actually we terminate that effective at this time, or are you talking about suspending it?
Oh, well, yeah, I probably used the wrong term. I would say we would suspend support now. I mean, to move this along as far as what the defendant is paying him at this point in time. I think that would be an act of graciousness as well.
Okay, thank you.
Your Honor,
Mr. Umlaugh, what's your response on the counseling issue?
firstly, I have not received opposing counsel's answer to my motion, but he and I have had extensive discussions on what he's presented today is not
3, 2,
1. The New York Times calls the holdovers laugh out loud funny.
Consistent with what he and I have talked about. As it relates to counseling with Margie Hunter, we would not oppose it. I did have an opportunity to speak with Margie Hunter, and she did confirm that while she had spoken with opposing counsel on this matter, she has never treated Mr. Pemberton or had any involvement with this family previous. And so I think she would be an appropriate counselor.
Okay,
However,
go ahead.
I would still note for the record that given the distance and the length of time, our position is still that this is a significant enough change of circumstances to warrant an evidentiary hearing to revisit legal and physical custody and certainly parenting time.
What we'll do is the court does believe that based upon the pleadings and basically the argument today, that the defendant has met the threshold of ABARCA for proper cause change in circumstances sufficient for an evidentiary hearing. The court will, in the interim, based upon the stipulation put on the record, the court will suspend the child support obligation effective today's date through the pendency of this until we have resolution of this matter. The court will further order counseling with Margaret Hunter. The parties can utilize that for purposes of, if you want to say co-parenting, or also for purposes of reintegration counseling, whatever you want to call that, but we will set it up in that manner. I'm going to give you some period of time, maybe 90 days of counseling before we would schedule the matter in, but we will contact your offices and find out a time when you're available after the 90 days. And hopefully Ms. Hunter can make some inroads and then make a recommendation to us at the end of the 90 days as to where we're going to proceed with counseling, or how the counseling is going, et cetera. Mr. Umlaugh, I'll ask that you would prepare the order, and you can submit under 7-day.
Well, one question, Your Honor, and that is, what about my request for discovery as we await the evidentiary hearing?
Well, you've got 90 days to while the counseling's going on. I guess you could effect discovery during that 90-day period.
Okay. Thank you, Your Honor.
You can put that in the order as well, Mr. Umlaugh.
Thank you, Your Honor.
Okay. Thank you. You're free to go. Have a good day.
Thank you, Your Honor.
Thank you.
This is why when you go to court, you need a mouthpiece. A lot of people come to these court sessions and don't have a mouthpiece, and honestly, they end up losing badly, like the prior video I just did. So at least mom was able to suspend her court-ordered child support payments because the children was living with her in the first place. So why was dad taking money from the mother if mom was the one taking care of the kids? He was having no overnights because he moved out of the city and won't provide an address to mom. In addition to, right, he's taking the money and the children are upset because now they don't have access to their father. I just think that a lot of these people just don't really think about things when they're going on with their life, and then they want to say, oh, I want to have a future. But you want to have a future in what? Because you're not thinking ahead, right? But nevertheless, this is Antonio, Team Tiggio. Please like, comment, subscribe, as we'll be coming to you more videos in the future.